court had decided what was argued yesterday on the application for leave for judicial review, and upon the consideration of all their submissions by both parties, the court read out a judgment, and in that judgment the court referred and did not deny the fact as to the existence of two very recent decisions of the federal court, which had very clearly stated that the provisions, any provisions of law enacted by the parliament cannot oust the jurisdiction or the judicial powers of the courts in Malaysia. And despite that, his lordship was of the opinion that since those decisions did not relate to political parties, and yet there is a section 18C which is specifically on political parties, and there are decisions earlier prior to that which validated the section 18C. So he was of the opinion that he's bound by section 18C, and he did not follow those very recent federal court decisions. In our opinion, that would appear to be in breach of the principle of stare decisis. I would go on record to say the judge had decided to ignore the clear decisions of the federal court, which stated any provision, mana-mana peruntukan, doesn't matter with the Societies Act, a Kindergarten Act, or Universities Act, or Election Act even. It is all inclusive. We shall appeal. Our instructions are to appeal. But as it stands, the application for leave of the 16 has been dismissed as at today.
Does this mean UMNO is in the clear then?
Well, for the time being, it would remain that the decision of the registrar and the decision of the Majlis Tertinggi remains. But if the appeal is to be allowed and remitted back here, then the question which we would like to pose is the issue as to whether UMNO would like to take the risk of fielding the candidates as a member of the coalition party of Barisan Nasional, and face the risk that if the appeal is allowed, then possibility of a national crisis as to the validity of its candidates will arise then. But that's up to the wisdom of the UMNO leadership to decide what they wish to do. Despite the decision today, because we have the right to appeal, advise the leadership of UMNO to consider, in the interest of the nation, not to use the logo of UMNO, albeit through Barisan Nasional, with regards to the candidates, so that we will avoid a possibility of extending the UMNO crisis into a national crisis.
Would it be accurate then to say that the doubt still exists?
To me, yes, the law is clear. The law is clear that the Registrar of Societies should not have granted extension, or rather agreed to the application to extend the elections beyond the 18 months already extended under clause 10.16. There is no power, there's no jurisdiction. This court today did not decide that. The court did not go into the merits, because it seems, according to the court, the society, UMNO, had a right to hide behind section 18C, meaning section 18C deprives this court to look into the merits, the legality or the illegality of the argument, since it cannot be brought to the court. So that is the first hurdle which will be tackled in the Court of Appeal as well. So that question, which has been discussed and pondered upon by many throughout the last couple of months, has not been answered today by this court. That must be made clear. Alright.
Kemudian kata hari ini bukan lagi ahli, so ada komen tentang tak boleh bawa ke tindakan ke mahkamah.
Dari segi itu, kalau saya nak komen, dia punya apa, saya belum dapat surat lagi tentang apa, tapi yang dia dalam kenyataannya pun dia kata berkuat kuasa pada 21 pada bulan April, sedangkan kita mulakan tindakan kita pada 20 April. Jadi pada masa tindakan tu diambil, kita masih ahli, dan dalam tindakan tu juga kita mohon pada mahkamah supaya menggantung sebarang tindakan pada kita, pada yang pemohon, sehingga kes diselesaikan. Dan bila rayuan ni kita akan filekan, bermakna kes tu masih lagi berterusan di mahkamah.